llevar hacia el punto de reunión establecido en el Jardín de los Lobos. En caso de emergencia, se activará la alarma de evacuación. Al escucharla, guarde la calma y siga la ruta de salida que localizó y que le llevará al punto de reunión establecido en el Jardín de los Lobos. No corra, no grite y no empuje. Siga las instrucciones de las brigadas de evacuación. En caso de sismo, se activará la alerta sísmica. Al escucharla, guarde la calma. Resguárdese en su lugar o en las zonas de menor riesgo que están debidamente señalizadas. Evite desplazarse mientras perciba el movimiento. Existen objetos que pueden lastimarle en caso de que caigan. Posterior al sismo, siga las indicaciones de las brigadas de evacuación. El día de hoy, no tenemos algún simulacro programado, por lo que, en caso de escuchar la alarma de evacuación o la alerta sísmica, siga las instrucciones de las brigadas de evacuación. Por su atención, muchas gracias.
Hola, bienvenidos y bienvenidas. Mi nombre es Pedro Martínez y a nombre del Departamento de Derecho les doy a todos la bienvenida. Hoy tenemos pues un invitado muy especial, el profesor Ryan Abbott. Así que bienvenidos. Welcome to everyone today. Professor Ryan Abbott is with us today, which is an honor for the university and for the law department. I will quickly introduce Dr. Abbott, and then we'll hand over the microphone to him. So Professor Abbott is Professor of Law and Health Sciences at the University of Surrey School of Law, Adjunct Assistant Professor of Medicine at the David Geffen School of Medicine at UCLA, partner of Brown, Airy, Smith & Kahn, and a mediator and arbitrator with JAMS Incorporated. He's the author of The Reasonable Robot, Artificial Intelligence and Law, published in 2020 by Cambridge University Press, as well as the editor of a research handbook on intellectual property and artificial intelligence, published in 2022 by Edward Elgar. He has published widely on issues associated with life sciences and intellectual property in leading legal, medical, and scientific books and journals, and his research has been featured prominently in the popular press, including the Times of London, the New York Times, the Financial Times, and other media outlets involving time. Professor Abbott has worked as an expert for, among others, the UK Parliament, the European Commission, the World Health Organization, and the World Intellectual Property Organization, WIPO. He's a licensed physician and a patent attorney in the US, and a solicitor advocate in England and Wales. Managing Intellectual Property magazine named him as one of the 50 most influential people in intellectual property in 2019, and again in 2021. Well, without further ado, I give the floor to Professor Abbott.
No, thank you. I think I've got this. Well, thank you very much, Pedro, for the overly generous introduction and for just running with the dad joke embedded in it for those of you who picked up on it. I've never stood on a podium in the middle of 3 sections of audiences, so I guess this is because the Taylor Swift concert was here a few days ago. I will do my best to just sort of pivot periodically throughout the talk. But someone had good planning on the order of speakers because, was everyone here for Chantal's talk earlier? Right? So hers was way better than mine. So a lot of people have already left, which is fine. But it's good order because she talked about some of the cool things that AI can do these days, and I'm going to talk more about what we should do about that legally. And in particular, one of the questions is, these things that she's having AI make, can she own them? Or can they be owned at all? And who would own them? And so she had really much better examples than I did, the Jennifer Lopez video and the AI video, but here's one I picked. You know, I talk about AI a lot and I have to keep updating the slides, and it used to be I could go a year without updating some neat thing AI was doing, and now every week AI is doing some new, even cooler thing. This is someone who built a AI model based on a large LLM platform, and it will let you take a picture of the food in your refrigerator, and it will make a recipe for you and tell you how to, make a meal. And this is a phenomenally complicated exercise. For me, I open the refrigerator, I look at a bunch of weird food, I close the door, and I order DoorDash, which is how we get food in America now. But instead, the AI will visually identify food, figure out what type of food it classifies as, figure out the amount of food, and figure out how to make a meal based on those ingredients and give you instructions for it in different ways. So there is really a lot of cognitive activity that has to take place to do these things, right? Someone asked at the end of the last session, are machines conscious, right? Or will they be conscious? And there's a whole lot of interesting stuff packed into that. One of which is how you define consciousness. There's conscious the way a person is, there's conscious the way a lower life form is, there may be a very narrow version of consciousness where you have one neural network generating content and another neural network evaluating the content, right? So there's really a lot of different ways to think about these things, and they touch on really ancient philosophical questions about what is thought and our place in the universe. Although I'd like to try and convince you that for the law, all of that's just totally irrelevant, which makes it a lot easier. Right? Starting with what is AI? And it's a strange sort of thing. The last speaker mentioned the term comes from a conference in 1956. And in about 70 years, people can still not agree on a definition for artificial intelligence. And it kind of didn't matter because it was just engineers talking to each other, so everyone knew what they were talking about, and if you couldn't define it precisely, so what? But it's different when lawyers talk about it because laws depend on definitions. And so we are passing these new laws and policies about artificial intelligence, and lots of people cannot agree on what artificial intelligence is or what intelligence is. For me, I think it all comes down to function. You have a machine that's behaving the way a person would behave. And it doesn't really matter whether it's an artificial neural network or traditional programming using logical rules that a programmer designed, or some modern deep learning systems where the programs are essentially self-programming based on exposure to data, because at the end of the day, you have a device that is behaving in a certain way, and we want the law to figure out what rules will maximize the benefits we get from this behavior and minimize the risks. People have very recently gotten really interested in artificial intelligence. So this is a slideshow from Equity, which is a performers union in the United Kingdom. And about a year and a half ago, they launched a campaign to stop AI stealing the show. And they were concerned that music and movie studios would use AI to replicate the likeness and style of actors like Jennifer Lopez, use it and not pay them adequate remuneration, or perhaps do away with the need for actors altogether. And that was before the release of all these modern generative open access systems. Now, the Writers Guild in the United States of America and the Actors Union are both on strike and have been for months. And one of the major reasons they say they are striking is artificial intelligence. They said they demanded that the music and movie studios would promise not to replace them with artificial intelligence. The studios said we're not going to do that, and now we have a strike. So these issues that have been around really for many years have suddenly become very socially important to people in an immediate sort of way. Some months ago, a number of prominent thought leaders in AI signed a letter saying that all AI development, with models more powerful than GTP-4, which is one of these large open access or somewhat open access large language models, should stop, because these AI thought leaders were concerned that AI was either going to literally destroy us or at least cause serious social problems. And so they called for a 6-month pause. That didn't happen, and it would have been very difficult for it to happen because if, for example, Mexico paused AI development for 6 months, Argentina might not. Some of it was a little self-serving. Elon Musk signed the letter and then launched his own AI company while he was asking everyone to pause. But this is something that people not only are concerned is going to take jobs, but they are existentially concerned about what AI is going to do. And this is a slightly older report, but just to make clear, some people at least think AI is going to result in a huge amount of money, right? A report by PricewaterhouseCoopers in 2020 said they thought it was going to generate about $16 trillion over 10 years, which is a lot of money. And an open question is whether that is all going to go to Jeff Bezos or whether the rest of us are going to get something. But it's going to be economically a big deal. So policymakers have started paying attention to this and realizing how disruptive it's going to be. And they're doing things. The most recent thing the United States did was the White House put out an AI Bill of Rights. So this was a list of things that the White House would like companies to do. Things like avoiding unfair bias and keeping a human in the loop in AI decision making. But it doesn't force any company to do something, it just asks companies to do something. The European Union, by contrast, is further ahead in this and is on the verge of passing an AI Act that is going to come up with some regulations on the industry. And it regulates AI according to risk, so there are certain high-risk uses of AI that no one will be allowed to do. For example, mass facial recognition in public places, with some exceptions, deceptive consumer marketing tactics, social scoring. So that is a practice where you may give a citizen a score based on how good of a citizen they are, like a credit score. And there were reports that some countries were doing this, and this was Europe's response to this to say you can't do that under any circumstances. In my view, that's a little bit problematic, and one of the reasons that AI can be complicated, which is that the Europeans don't really have as much of a problem with AI social scoring as they do with the entire concept of social scoring. You could also have a building full of people doing social scoring on a paper and pencil. And so it may really be that what you want is a law saying you can't do social scoring, not a law saying you can't use AI to do social scoring. One of the areas I've been most interested in, and which follows in nicely from this morning's presentation, has been intellectual property law and artificial intelligence. So, there is property that is tangible property like this podium, or real property like this building, or intellectual property that is certain sorts of intangible things. So if you write a book, you have a copyright in the book. If you come up with an invention, you can get a patent on your invention and keep other people from making it. If you have a brand like Coca-Cola, you can protect your brand from other people doing certain things with it. And artificial intelligence is going to have some really significant impacts on intellectual property, both because of the way that it uses it and because of the way that it generates things. And this is something that policymakers have also recently gotten interested in. The United States Patent and Trademark Office recently launched a request for public comments on artificial intelligence and inventorship. So what happens if you have an AI that acts as an inventor? Say you ask an AI, instead of making a movie like you saw earlier, to design a new drug to treat COVID. And what happens if it makes that drug? How should that sort of thing be handled? People are also concerned about how AI is ingesting data. So not all AI, but a lot of very popular AI applications now are based on machine learning and deep learning, as you saw, and large language models are. And the way those AIs learn to function is they are trained on data. So for example, I could take a picture of all of you, show it to an AI, and ask it to recognize whether or not it had seen you before when you're coming in through the booth, right? And I wouldn't program it how to do that. I wouldn't tell it how to figure out what noses look like and how eyes look and the size of things. I would just show it pictures, and I would give it some associated information with that, and it could learn to do certain functions. One AI that does that is run by a company called Clearview, and Clearview makes AI for law enforcement. So if they license their AI to a police officer and she stops you, she may look at the device and it may give her your name, it may show her pictures of you from social media. People are concerned about this because it seems invasive and potentially problematic. But from an intellectual property perspective, it's also concerning because the reason the AI is able to do that is it has looked at 10 billion photographs from the internet, including all the major social media sites. So your pictures, if you're on social media, and looking at the age of the audience, you're probably all on social media, is probably somewhere in a Clearview system somewhere, or at least their AIs have trained on your pictures. AI can make images now that don't really exist. So you saw Jennifer Lopez. That is not really a picture of the Pope on the left, but it fooled the internet pretty well, and I think he actually looks pretty good in Balenciaga. Pretty harmless, right? This also is not a real picture. It didn't fool the internet quite so much because there's a few more obvious telltale signs that this was AI generated. For complex technical reasons, AI really struggles with hands. But you could imagine as this technology gets better very quickly at making realistic images, how you could make some images that someone could not determine easily were AI generated, and you could use those for political disinformation or for commercial disinformation or for personal revenge on someone. And of course, money's at issue. So I'm going to look it up later today, but I would bet that Virgin paid Jennifer Lopez a bunch of money to do that, even though she didn't have to do anything. By contrast, Bruce Willis is also appearing in a lot of advertisements in Russian advertisements, but apparently not getting paid for it, right? And so this raises, again, all sorts of interesting questions. Do you need to pay Bruce Willis? He's probably going to have a hard time enforcing his rights in Russia, but even in the United States, that's somewhat of an open question. Whether someone's name, likeness, image, and style are protected, are long-standing questions we've had in intellectual property law, but have changed a bit because AI has made it a lot easier to do that. So for example, if I was able to personally sing in the style of Taylor Swift, there's nothing she could do to stop that because you can't copyright style, usually, right? Maybe that's a little different if I have an AI that can make incredibly good Taylor Swift-like music, maybe even better than Taylor Swift-like music. Does there have to be permission from her or accounting? And AI is doing some things that aren't that great. So how many of you have used ChatGPT? A lot of you. How many of you have used it to write your assignments and term papers? All right, we've got some honest students there. So you must be in the ethics department. ChatGPT is very good at coming up with text in large amounts and very quickly. And sometimes it sounds very coherent, and sometimes it completely does not. ChatGPT is also very good at sounding very confident about things that are completely incorrect. So if you ask ChatGPT, what has Ryan Abbott been accused of doing? It may say something like he's been accused of murder, as cited in this New York Times report, except that I don't think I have been, and there'd be no such New York Times report. So a couple of months ago, a lawyer in the United States made headlines when he asked ChatGPT to write a brief in his case, and he turned it in without reading it, and it made up a bunch of cases that didn't exist, and the judge got rather upset at him. Then he lied about it, but he didn't actually get any professional discipline. So if ChatGPT says something about you that would be illegal if a person said it, like say you have a terrible, you're a criminal, can you sue the company behind ChatGPT or not? Is it a communication which is required for defamation in the United States if it is a communication made only by a machine to one person? Who is responsible and on what basis, and what sort of mental state does someone need? These are all questions that courts are now getting into doing. So I want to talk a little bit about one of the issues on this, which is, can you own the stuff coming out of an AI system? And I want to start talking about copyright. So, generally, if I take a photograph or draw or paint a painting. I'm the author of that. I get a copyright in it. My copyright lasts as long as I live, plus 70 or 50 years, depending on the country you live in. And that stops anyone else from making it or using it, with some exceptions, right? But it's mine. But what if I ask Midjourney to make a modern take on Girl with a Pearl Earring, which is a famous photograph, which this was? Do I get a copyright in that? Does Midjourney get a copyright in that? Does nobody get a copyright in that? If nobody gets a copyright in it, it's in the public domain, and anyone can do whatever they want with it. So those pictures and those videos you saw, if no one owns them, regardless of how much time and effort went into making them, if no one owns them, then anyone can use them. The United Kingdom was the first country to pass a law about this, and it passed it in 1988. At the time, the British Computer Society thought that this issue was so important, if a law was not quickly passed, this was going to be a major problem in the creative industry. So it turned out they were about 30 years too far in advance for this. There's only been one case on it, and even then it wasn't much of a case. But now suddenly, this really is an issue, and at least the United Kingdom has a law on it. So in the United Kingdom, if you don't have a traditional author, if you have a machine make something the way an author would, it's called a computer-generated work. It gets a little bit less protection. It gets 50 years. It's not based on the life of the author because machines don't die or live. And the producer of the work owns it and is legally considered the author. So that's the person who undertakes to have the work created. That would be in the case of GTP, whoever prompted it, likely. But the United States has gone in the opposite direction. And they've had a Copyright Office policy since 1973 that says, if you don't have a traditional human author, the work is inherently unprotectable. And the reasoning for this is based on a Supreme Court case from 1884 called Burrough-Giles v. Cerrone. And it involved this very famous photograph of Oscar Wilde. And at the time, the Copyright Act in the US did not say that photographs were protected. The US Constitution allows the writings of authors to be protected, and literally, a photograph is not a writing. And so when someone used this image without permission, the photographer said, "This is mine, I own it," and the infringer said, "No one can own this. It's a mechanical reproduction of a natural phenomenon. It isn't a drawing of an author." And the Supreme Court said, "We disagree with that. We're going to interpret writings liberally. It's really any tangible idea in the mind of an author that's given expression is eligible for protection." And the Copyright Office has interpreted this to mean that because machines don't have minds in their view, that nothing that comes out of them can be protected if they have functionally authored it. And not just machines, but also monkeys. So up until very recently, there'd never been a case on this, but there was this one famous case involving the monkey selfies. Who's seen this photograph? A good number of you. So this is Naruto, and Naruto took his own photograph, and he's smiling, and people think it is adorable. Actually, he's a black-crested macaque, and black-crested macaques smile as a display of aggression, so he's probably seeing his own image in the camera lens and trying to intimidate that monkey. But in any case, people like the photograph, so much so that the guy who owned the camera said, "This is mine, and if you want it, you need to license it." And people said, "No, it's not yours. A monkey took it, and a monkey can't be an author." So that seemed to be the end of it until PETA, People for the Ethical Treatment of Animals, sued the photographer in federal court in California and said the monkey was the author, and they were going to help the monkey bring the lawsuit. So that case did get dismissed, but not based on a human authorship requirement. It got dismissed based on standing. The court said, unless Congress is going to very plainly state that animals can sue under the Copyright Act, we're not going to let them sue under the Copyright Act. Which to me was kind of funny because, of course, human beings are animals, and human beings sue under the Copyright Act all the time. So one does have to be careful with their language. So I have a case where we filed to register an AI-generated artwork with the Copyright Office. And the claim was that an AI made this, but there's nothing under US law that protects that sort of thing from getting protection. And just last week, I think, a federal judge in the District of Columbia decided that we were not entitled to a copyright registration. And the judge said, creativity is inherently human-centric, and if you do not have a human author executing traditional elements of authorship, the work is inherently unprotectable, regardless of what anyone else has done. So we are planning to appeal that. There are other cases, none yet in the courts, but that have been with the Copyright Office on this, and this is an excerpt from a work of visual art called Zarya of the Dawn. It was a comic book that a human artist made using Midjourney. And the artist put in text prompts, you know, I would like a girl and a stuffed animal together in a small room. The human artist really did very detailed text prompting. You know, there is an art to getting good stuff out of Midjourney by phrasing prompts. I'm very bad at it. This person is really very good at it. So they had a lot of direct involvement in the prompting. And they submitted it to the Copyright Office and said, you know, this is mine, it came out of Midjourney, but I'm the author, I put all the prompts in, I picked the images and so forth. And the Copyright Office said, no, this came out of a machine, it's an AI-generated work, and you can't protect this, right? So right now in the United States, the law is, when you use these generative AI systems to make content, no one can own it. That's a bit on the ownership front. What people are even more concerned about right now is this training issue, right? So I mentioned with Clearview that the way you would train an AI to recognize faces was to show it images of faces. The way that most of these generative art systems work is that they've been trained on people's art. And different artists have very different feelings about whether that's acceptable to them, right? Some people say, I want payment for you to be able to train your AI on my work. Some people say, I don't care about payment, I don't want you to be able to use my work at all. Right? Now, with human beings, you can't stop someone from training on your work, but when you are training an AI on work, it does involve copying the work many times, so there is an infringement unless there's an exception to infringement. In the US, we have a doctrine called fair use, which basically means sometimes you get to use someone's work without permission, and so there are now a bunch of cases in the US about whether this is permitted or whether it's fair use. These are images taken from a complaint filed by Getty Images, and Getty Images is a large right holder in the United States. They own the rights to lots and lots of images, and they're suing a company called Stability AI that built a generative AI system using their images. So you can see on the left there is an image from Getty Images, and on the right is an image made by Stability AI. And so just looking at this, you have a pretty good idea that it trained on the first image to make this, given how similar the images are and the fact that the Getty Images watermark was taken. Now, in the United States, the damages for willful copyright infringement are fairly staggering on a per-use basis, so hundreds of thousands of dollars. So if Stability AI were found liable for each instance of training for hundreds of thousands of dollars, you know, the damages could be millions or billions of dollars. So there is a lot of liability potentially associated with these uses, and the courts have not yet said whether or not this sort of use is acceptable. And in the meantime, Stability AI is up for anyone to use, and if you're using Stability AI, and this is infringing, you may also be committing infringement by using an infringing system or having it make infringing output. So these are big, very financially important questions that haven't been resolved yet, but it's going to take years and years for courts to resolve them. And meanwhile, what are people to do with these systems? That's a bit on the copyright front. I'd like to talk about the patent front for a bit. Right? And so just the way you can have Midjourney making images, you could have an AI contributing in the inventive process. This is a still shot from a video made by a team at Google that talked about an AI that they developed using deep reinforcement learning to generate chip floor plans. So a chip floor plan is how you arrange components in a microchip, And how you do that affects how the chip functions, how much power it needs, how much wire you need to use, and so forth. And these chip floor plans are very important to companies like Intel that make microchips. And the team at Google says it takes a team of people months to make a new floor plan, an interdisciplinary team of people, and their AI can make a new one in under 6 hours, and the AI-made chips outperform the human-made chips on all key performance indicators, right? So if you really could set up an AI to just start sending out these new designs, that would normally be a patentable sort of thing, and you have this same question. Well, if I don't have a traditional inventor, what can I do about this? This is a case study that Siemens presented as far back as 2018, and the green thing is a car suspension, and the silver thing is a car suspension designed using AI. And Siemens decided that they could not file for a patent on the silver thing because all the engineers involved in making it refused to say they were inventors. They basically said, we took an AI that could optimize industrial components, we gave it designs that were publicly available, it modeled the fitness of its own output, the output was obviously valuable, none of us did anything that would qualify us to be inventors. And this is important because to get a patent, you need to have an inventor. But if you list the wrong inventor, in the United States at least, you can lose your patent. And in fact, it is a criminal offense in the United States to say you're an inventor if you don't believe yourself to be. So we also did another case, this time with patents, where we had an AI generate 2 inventions. And this is one of them. It's called the fractal container. And you saw earlier some very pretty images of interior designs based on fractal geometry. This is a beverage container based on fractal geometry. The machine predicted that would make it easier to grip and that it would improve heat transfer, like an antithermos. So I had my university make a couple of prototypes. It is, in fact, surprisingly easy to grip. It is also incredibly difficult to drink out of. It is also effectively impossible to clean if you put anything other than water in it, but, you know, it's an invention. We filed for the invention in the UK with the patent office and didn't tell them about the AI. And they did an analysis and they said, okay, this should get a patent. It's new, it's non-obvious, it has industrial applicability. And then we said, well, actually, the person filing for this is the person who owns the AI, but this was invented by an AI called Davis. And we'd still like our patent, thank you very much. And we ended up filing this application in 18 different countries. And the reason we listed the inventor as Davis, the AI, was because the human being who built the AI hadn't done anything directly inventive with respect to those inventions, and to be transparent about how the thing was invented. Now, it's just a machine, so it can't own property. It's not a legal person, so it would never own a patent. And what would it do with one anyway, right? But the basic argument is that the person who owns the AI would own the invention. The same way that if I own a 3D printer and it makes a tangible piece of property, I would own that. But laws around the world were not particularly developed to deal with this, and so we've had an interesting response so far. We did get a patent issued in South Africa in 2021 with the AI listed as the inventor and the owner of the AI as the owner of the patent. And more recently, Saudi Arabia has also agreed to do this. A few days after that, Justice Beach in the Federal Court of Australia ruled that under the Australian Patent Act, an AI could be an inventor, and at least in our case, the AI's owner had the best claim of ownership to the patent. Now, unfortunately, some of his colleagues disagreed and overturned that decision, but it did stand for a brief shining moment. The European Patent Office said, well, an inventor has to be a human being, but there's no reason under European law that you couldn't just say that the owner of an inventive machine is a patent inventor, and you can even write in the patent this was AI generated. So we are continuing with that, and a court in Germany has said something similar. In March, I argued this case to the UK Supreme Court. Previously, the Court of Appeal split on it, but ruled against us. And the argument in the United Kingdom is, You don't need a human inventor. You only need to disclose the names of human inventors, and here there is no one to disclose, and we should still get a patent. And in the United States, the Federal Circuit said, no, you can't have a patent because the law says that an inventor has to be an individual, and we don't think an individual can be something other than a natural person in this context. So you've seen different courts coming out on this differently, which is also really a challenge because in a globalized economy, if you invent something in Mexico, you want it to be protected in the United States and in Europe, and as it is now, only some places are protecting this sort of thing. And the argument for why protection is important is not that the AI cares that a patent is granted, because of course it doesn't, but because most patents are already owned by artificial persons in the form of companies that have to invest in hiring people to do research. And it may be in a few years that instead of a big drug company like Pfizer going to a room full of pharmacologists and asking them to find a new cure for COVID, they go to a room full of supercomputers and computer scientists and have AI sequence a new pathogen, design a new vaccine, and design clinical trials. So that's a bit on ownership, but there's also all sorts of standards in the law that are very human-centric that are going to be changed the more machines behave like people. So to get a patent, the main test is that the invention has to be non-obvious to an average researcher. And there's all sorts of things we think about an average researcher. They're not someone who's invented a bunch, they don't have a PhD. Because the more sophisticated an average researcher is, the harder it would be for you to get a patent. Well, already, average researchers are using AI in research and development, and so it makes average people more knowledgeable and more sophisticated, and so more should be obvious to them, and it should be harder to get patents when your normal researcher is someone who's using an AI system like GTP4, although that's not particularly for invention. One way to think about how this might work is in drug development. So this is an antibody, and all of the best-selling biological drugs are antibodies. An antibody is something that your body makes to fight a pathogen. It can be COVID, it could be cancer. And the body basically does this by rearranging amino acids so that they bind to a particular target. And there's a lot of ways to make an antibody, at least trillions. Enough for your body to make them against whatever it needs to. But there is a finite number of ways to string amino acids together. And so it's not too hard to imagine that a sufficiently powerful computer could just say, this is every possible antibody. And computers can now also model what antibodies look like in 3 dimensions, how antibodies bind to known targets, how antibodies interact with other drugs. So you could have a computer say, here's every possible antibody, and here's what it binds to. And in principle, that sort of thing could be used to cure cancer. You could take a sample of your cancer, you could analyze it, you could go through the full library of existing antibodies and have a 3D printer make a treatment just for you and your cancer. Among other things, that's also going to make it impossible to get new patents on antibodies because they would all be known and obvious to a computer like that. And, lest that sound too science fiction-y, both DeepMind, which is owned by Google, and Meta have announced that they've built AI to predict the shape of every protein essentially known to people in 3 dimensions. And that can be a task in drug discovery that is a bottleneck. So they are working at solving these fundamental scientific problems using AI, and it's really going to change how research and discovery is done. There's a concept in computer science called the technological singularity. It's an old concept. It was popularized by Ray Kurzweil. But the idea is that computing capabilities are improving, and they're improving exponentially. And the better computers get, the faster they will continue improving. At some point, you are going to have computers that can improve themselves, right? In fact, one of the things computers are very good at now is automatically generating software code. And at some point, computing capability will match human computing capability, and the AI will start improving itself, and you will get this runaway progress, and you will have super intelligent artificial intelligence that will not only solve all the problems we know we have, but even problems we don't know we have, right? Either that or it will destroy all of us. But it will also make it impossible to get a patent because everything would be obvious to the AI. It would take a real patent nerd to care about patents if that happens. And I will stop there and take some questions and hope that help maybe raise some questions for you about the legal treatment of machine behavior.
Muchas gracias al profesor Abbott, y si hay preguntas, por favor, levanten la mano y les pasamos el micrófono. Sí, veo una allá atrás y después acá adelante, por favor.
Hi, got a couple of questions. First one would be, if you have an autonomous system, AI system, that has to make a decision that would have legal consequences, in the end, who would be liable? You know, the owner, the AI, or the, I don't know, the developer? That would be the first one.
Sure. So this is one of the big questions people are concerned about, which is liability for AI behavior and who is liable, right? Clearly not the AI for various reasons, including because if it was liable, it wouldn't have any assets to pay you, right? So if that's the case, then who's liable? And different jurisdictions do this differently. And to give you the lawyer's answer, it depends, right? So there may be cases in which the owner, the developer, the user, or all three of those are liable for AI behavior. So if you take the example of a self-driving car, I have a self-driving car. It's really very bad. I don't use it that much because it's incredibly dangerous, and so there's that. But that's a commercial product. So generally when a commercial product causes harm, the manufacturer and supplier of the product is responsible for it. So in my case, if my self-driving car ran someone over, Tesla would be liable for it. That said, Tesla says, we aren't liable for it because you, the driver, regardless of what our AI does, is responsible for driving the car. And if it looks like the car is going to mess up, you need to grab the wheel. Right? Now in practice, we know that people don't do that. People start not paying attention. Right? And so we are going to have a lot of legal battles over who is liable in these circumstances. But generally, where you have a commercial product like ChatGPT or a self-driving car, the manufacturer is liable for it. But it depends on the facts. There are also other laws that dictate when you can have automated decision-making and when you have to have people involved. So for example, in the European Union, you have to have a right of recourse to a human decision-maker for any automated credit decision, right? So now when you apply for credit, an AI tells you very quickly whether you get credit or not. And in the European Union, you have a right to appeal that to a person. You know, but this will also increasingly be based on statute.
Okay, and the second question was related to the first one. But if you have a situation where you need to train the system, the machine learning system, with some ethical questions, like the self-driving car, for example, if you have, I don't know, an old people and a kid and a woman and man who you're going to give preference of running over, right? And probably it's going to change from country to country. Probably in our area, countries will be different from the U.S., from Mexico, from anywhere. So how is that going to affect, you know, in a product that's supposed to be global, with some ethical questions that are going to be cultural based?
Sure. Well, you know, it's a good question. Something else people are very concerned about, and in legal philosophy, we refer to this as the trolley problem, right? So many of you first-year law students will have been tortured by the trolley problem, which basically boils down to, if you have to hit someone with your Tesla, you know, do you pick the young person, do you pick the old person, do you pick one person, do you pick two people? almost everyone agrees better to hit one person than two people. But a lot of these decisions are normative and relative, right? Different cultures, there was a study done at MIT involving something they called the MIT moral machine, and it surveyed people in different countries. And in the United States, the preference was overwhelmingly, if you have to pick someone to hit with your car, and it's a young person or an old person, you hit the old person. They've had more life. In Japan, the preference was overwhelmingly, you hit the young person, because there's more of a culture of respect for elders there. Mm-hmm. So, those are ethical preferences, which is complicated as how it relates to legal preferences. It's also complicated because with human drivers, we don't necessarily demand that they make these decisions, and we certainly don't demand that they explicitly make them up front, right? Like in practice, you probably haven't given a lot of thought to that question. Now let's say you're driving along and you see a young person and an old person. By the way, you're not gonna have time to sit there and think, should I hit the old or the young person? Well, let me weigh the benefits and cons of each. But you could do that with an AI, right? You could program it in advance. Largely what they're doing about that is they're not capturing data like gender and age to avoid the AI having to make decisions like that. I also think this will not be a huge problem in the self-driving car arena because these cars are terribly dangerous right now, but in principle, they won't be in 10 years. Mm-hmm. And in principle, in 10 years, they may almost never cause accidents. So it's unlikely that the car is going to have to make a decision about who it's going to hit rather than just hitting the brakes. But there are, risk and ethical preferences and legal preferences people put in. And, there's a question about whether the manufacturers should pre-select that or let drivers do it, whether drivers should, for example, pick if they want the car to preference their own lives versus pedestrians, right? And what I can say is there is a body of law around what decisions people can make about that. And I would say, in the absence of a specific rule on it, the same body of law would apply to the car. So if it would be illegal for you to pick to hit a young person versus an old person, right, that would be the same for a car making that decision for the manufacturer. If someone had to hit someone and it didn't matter, then there wouldn't be liability for it.
Okay. Thank you.
Thank you. We had another question.
First of all, thank you for the great talk you gave us. And I had a question about the possibility of split ownership. So what do you think would happen if, a machine is not a legal person, as you said, but who in respect to that machine's outputs is? Like, would it be the manufacturer of the machine, the actual inventor of the machine, the developer of the program, the prompter with the creative idea that has been expressed? Or do you think that maybe a better idea would be, like, instead of just saying, so this is somebody's invention or this is the manufacturer's has the copyright or anything, maybe we could have like a split copyright, like maybe someone would determine, or a program could determine, like, who gets how much or how big of a piece from that specific invention. So for example, like the manufacturer could have some of it, because after all, you're using it for your invention, but then the actual person who prompted it has like the creative rights on it, because they had the idea that has been like expressed now in a material form. So do you think that could be a possibility, or would it be even more problematic than the actual conflict today is?
Well, you asked whether it was possible, so I think the answer to that is certainly yes, right? You could really have any ownership rule that you wanted, right? The user could own it, the owner could own it, the programmer could own it. Property law economists will tell you that the important thing is that you have a default rule and that it's clear and that it's easy to transact. So let's say we say, the person who has the rights to the system, like Midjourney, owns anything that comes out of Midjourney, right? They can then agree with users to transfer those rights. So Midjourney may say, all right, we own it, but you use our system, we give you any copyright in anything that comes out. And maybe they charge them for that. And maybe Stability AI says, you can use our system for free, but we own whatever comes out of it, right? So people in a market will come to different arrangements that they want based on ownership in advance, based on how they're using it, if you have clear property rules. You know, one of the challenges I think with allocating ownership between three parties in that scenario is it gets factually very complicated very quickly. So like the developers at OpenAI who made ChatGPT, maybe 10,000 different developers spread over 10 years, you know, who there gets ownership and how many of them? You know, and the reason I think it may work better to have owners own the rights as a default is that's more consistent with current property rules and because it will encourage owners to grant access to more users. But you could totally have a different rule.
And what about like a default separate copyright? Like you would have like just a general global law or national law or something that would say like this percentage goes to an AI, like whoever created the AI or owns the AI, and then this percentage goes to the creative identity of the person who prompted it, etc. Like, do you think maybe we could achieve something like that, like a consensus that says just how much of it belongs to each of the participants in the creation of that invention?
You could totally have a law like that, right? I mean, you would need to pass a new law, but there's no reason you couldn't do it. I just think it might be a little complicated for each thing that comes out of Midjourney to try and figure out how much goes to Midjourney versus a user versus the many people who may have programmed it over time. You know, I think single party ownership probably works better as a property rule, but again, you could completely do that.
Thank you.
Thank you. We have time for only one more question, which will be here. It had been requested before. Sorry, we're a bit pressed on time, so.
But if anyone wants to ask me after, I'm happy to answer questions.
We have time afterwards, so yeah. Thank you.
Hey, thanks for the talk. My question is like if you have a personal opinion on AIs being mentioned as inventors, like in a global criteria per se. And the second question is if you foresee any consequence, like in the US regulation where they do not accept the AIs being named as an inventor. Do you see any consequences in the future, like in the markets or anything like that?
Sure. So my view is that the factual inventor should be listed as the legal inventor. So if something was invented by an AI, the AI should be listed as having invented it. And the reason for that is two. One, it's transparent. So, you know, a lot of talk about artists and architects this morning. You know, I have very little artistic capability and I have no architectural capabilities. But let's say I wrote to prompted Midjourney to say, make the most fabulous building in the history of the world, and it does, right? And it's built here in Mexico City, and every architect in the world says this is the greatest achievement anyone's done. Should I be able to say that I made that, right? In my view, I'd say no, right? You should accurately say what was done. Like this came out of Midjourney, Midjourney authored it, and I own it, but I'm not taking credit for work I haven't done. And to do otherwise would dilute, I think, the meaning of legitimate human authorship and inventorship. The other reason to do it is that if someone is going to own AI output, that is transparent about who will own it then, because it describes the system being used. Consequences of not allowing it, I think, are twofold. One, it's an invitation to lie, right? So to the Copyright Office in particular, they don't really check these things. If you submit Midjourney work as your work, they will register it if you put your name on it. Now, you're not supposed to, but how well do you think they're going to catch you? Not terribly well, right? Secondly, if you are going to be, legal about it, it's a big disincentive. It says to drug companies, well, we'd better not use AI to make new drugs because what if we don't get a patent on it and we think we really need these patents? So, these are all reasons why I think what we'd argued in the case was the right approach. And now the US Congress is considering it. They had hearings recently on it. I was in one of those hearings, so perhaps they will change their mind or change the law.
Muy bien. Bueno, muchísimas gracias. Muchos aplausos a Ryan. Pasamos, nuestro vicerrector va a hacer entrega de un pequeño reconocimiento.
Thank you.
Muy bien. Bueno, ahora pasamos, les hacemos una invitación a todas las personas que se registraron al taller de Ryan Abbott para que permanezcan en este auditorio. Y a todos los demás les damos las gracias por haber asistido a esta conferencia y les pedimos pasen a las siguientes actividades y si tuvieran alguna duda, las personas afuera les pueden asistir. Muchísimas gracias.